It's hello again. All right. See, I'm modeling this behavior here by listening to the intro with you all and sort of cleaning my palate with you all here. So, all right. I hopefully today will be a bit lighthearted only because it's so tragic. You'll find that usually nothing like a tense moment to bring out a decent joke from yours truly or possibly a goat thing. On that note, I love the push button features in this goat screaming device here. If there's one possible criticism, I would say is this. Susan the goat, or the sort of the goats that are named Susan who get to be in charge of the herd, they're more of like a ah, and it's that sound in particular that pierces my soul from years of demands, of what the heck, guys. Mostly, by the way, their number one concern is that everybody knows good and well that I could let them out into the cornfield if I wanted to, and all that I would have to do is just do it. So let's go here, Ben. That's the main message I get from that voice. I don't know precisely what this means. And I have fairly good communication strategies with goats in general, but I see what I'm saying. I mean, I think we're supposed to interpret that as a, just a scream or some weird thing or just a sound. I don't know. I think I go off of what Mike uses, which is to like indicate the Karen screaming or something like that. Or what's the male version of a Karen? Anyways, somebody clueless screaming in pain from assuming that the world should consider them their number one priority. So, all right, here is what we want to go through right now. As you know, we have sort of took a pause in the MPS stuff. We're going to get back to that, but here is one of the reasons why. So, as we mentioned, Jackie Mann did not appear for her deposition. We showed you all of that. There was a lot of tension that was leading up to it, and there was a hearing that was scheduled for February 5th that was postponed. Ultimately, because MPS had just stalled on all discovery and had kept us from getting anything done. There was some serious issues with the Equal Rights Division and their scheduling of the hearing and them trying to make it be on virtual and the notices and all of that was tied up there with John Gelhard's failure to notice us in the games that he was playing there, trying to have hearings on whatever issues that he wanted to have them on without actually noticing anybody. So we objected to all that. We also made it very clear that we were getting some mail from the ERD and other mail we weren't getting from the ERD. And I think we've made that point known, and it doesn't seem like we've had that problem since then. So it's just disappointing, but hey, that's how it goes. So Jackie Mann scheduled to testify 9 o'clock, January 5th, something along those lines. If January 5th is a Friday, then it's the Monday. Okay, great. As you know, because we have the video, you can see Ryan sitting around chit-chatting with the court reporter and acting like everything's fine and that they don't know what the heck's going on. Well, I was down in my room doing, work because that's what I'm paid to do and I don't want to sit around. So I was occupied in that. My client was occupied sort of waiting. I asked them not to leave the room because we've had problems with certainly Chris Reardon and Ryan Maloney, but certainly Chris Reardon talking to represented parties, meaning my clients, when I wasn't there For example, he told Debbie Keither that he couldn't wait to depose her, and I believe that he called her a coward as well. In my office, he did that. So that was, we have to have two people there sort of to monitor their conduct. So although we had Chris Reardon had Ryan Maloney show up, we were still all waiting around. So at about 9:09, my client got a voicemail here, and let me play the recording. Hopefully we can all hear it here.
January 8th, 9:09 a.m. from an outside caller at 414-934-7000.
So, I'm sorry, we're going to get back to that in a second. That telephone number there, as MPS watchers will know, is an extension located in the Milwaukee High School of the Arts, a building entirely controlled by the Milwaukee Public Schools, and whose security control who enters and exits that during the school day, 9:09.
00. To delete this message,
we'll play that again. I don't know if I can turn it up much more, but we'll see what it can do.
34700. To delete this message, press 4. To reply to this message, press...
So, I assume you heard all that. It's not that loud there, but it's pretty clear. I heard 4 of them. And I guess I'm playing a self-censorship game here. What in the hell have we come to? It's kind of shocking there. So again, this is a call from an MPS school building during the school day, 9:09 a.m., leaving that message, call, hang up, with the 4 things in there. Let's say that, to me, that's a threat of violence. I think to the client, that's also a threat of violence here. So we have to thank MPS for putting that into the public record. They have submitted that recording, so thanks to them. That helps us out a lot. Just for example, just so we're clear on that, let's just say they hadn't put that in the public record by putting it in the case file in the ERD. Since that was an employment, let's just say, I don't know particularly, but we're going to assume some facts. If this is a message coming from an employer's phone to another employer's phone, for example, it's not her personal cell phone, or I don't know, like a work phone, for example, okay? During work time, and presumably everybody's an employee, whether it's a crime or not, that's a different story, okay? You cannot, as an employee, go and put that recording into the public record on your own. It could get into the public record, for example, if it becomes part of a police report, if it's an ERD case file, if, for example, the employer's attorney sends a public letter to a public officer, that being an ERD hearing examiner, that would make that letter public and that recording public. So just keep that in mind out there for people who are sort of trying to navigate that. All right. Give me 1 second here, please. Why'd you low again? All right. I really sometimes hate this OBS and making the windows the right size, but we'll get there. So this is an email from the Von Briesen law firm. Just again, to keep in mind how small of a world this is, that there's a Von Briesen grandson who happens to be my best friend out there in the world, and that another Von Briesen grandson worked for the Cross law firm for 5-6 years, and is also the person who is responsible more or less because of he's sort of the central access of how I met my wife, just for example. And these people are directly related to that Von Briesen up there on the screen. At least one of, I don't know if it's Von Briesen or whatever, but it's one of those guys. Definitely not Roper, that we can be sure of. Okay, so pretty amusing. So here is their letter. By the way, Chris and company have an excellent staff there, which I'm sure they bill for the city taxpayers of the city of Milwaukee. The pupils of the city of Milwaukee are having books stolen out of their mouths for this. They have an excellent staff, and their production is always top notch. I'll give it that. The legal ideas undergirding those production of the correspondence may be a different level, but the production is always top notch. All right. So February 15th, here we go. This letter is response to the accusations contained in Attorney Hitchcock Cross's February 14th. Well, I guess to be fair, I should probably pull that out. So if you'll bear with me, I will go and get that. All right, I think we're getting there. Somehow I have this on my old meeting bifocals font here. So subject, MPS threatens complainant with violence. Fulleron v. Milwaukee Board of School Directors. All right. Judge Reinhardt, I need to alert you that now MPS is blatantly attacking the authority of this tribunal and the Department of Workforce Development by threatening complainants, including Ms. Fulleron, who come before the tribunal with their equal rights complaints. I understand that on January 5th, the day of the Jackie Mann deposition, while the respondent and its attorneys knew that Jackie Mann would not show, but waited around and made jokes with the court reporter, an unknown caller from an MPS phone located in a secure MPS building called my client at 9:09 a.m. and left a voicemail containing 4 before hanging up. We obviously connect the timing of the call and the location of the caller and the timing of the call with MPS management and its blocking of Jackie Mann's testimony and pretending not to know where its active employee and board officer is. One can only imagine what would have happened to my client had the hearing occurred as scheduled. She fears for her life and is now out on FMLA under the care of a physician. I will draw a straight line from the frivolous motions of the respondent against my clients, the failure of the DWD to respond, and MPS's violence towards my client. It is not an isolated incident, nor the first time that MPS management has attacked a complainant, nor one of my clients. And to be clear, among other people, that means Dr. Holliday allegedly assaulting Debbie Keither while at MPS Central Office, while Debbie Keither is serving him with a subpoena for the Garcia-Hoven hearing, which, by the way, that judge in that case, that's Stephanie Brown, refused to enforce. She took testimony on the assault, alleged assault, and there's record in 15 minutes, and she asked Debbie Keither for 15 minutes about what happened, and that's in there. By the way, there is supposed to be and there has supposed to have been a trial on that before Judge Valerie Hill. That keeps getting postponed, as I understand it. We have sent a letter to Judge Hill asking her to allow us to record that trial, but so far she has not responded. This is a municipal court judge for Milwaukee Municipal Court, Judge Valerie Hill. And I think it's fair to say that the Milwaukee Municipal Court is not generally favorable to anybody watching its proceedings. It's certainly not by video. And I base that experience, that knowledge on my experience of trying to have the victim in this case be able to appear or listen in by Zoom. So they give the defendants the right to listen by Zoom and to appear by Zoom, but the victims have to show up and go through a whole rigmarole, which is not easy to get downtown to do. and certainly to get through their whole their security and all of their rules, regulations, and yeah, I don't know what else to say it. I mean, I would not like to run. I wouldn't like to make signage for the Milwaukee Municipal Court. Let's put it like that. I would think that would be a difficult thing to do. So, that's that a piece of violence. Remember, I often say that Posleyism, that's violence in support of ignorance. And I think this is another example on that. Nor the first time we have implored the department, that's the Department of Workforce Development, to prevent MPS violence. Naturally, we anticipate extensive motions flowing from this latest outrage. We filed a complaint for retaliation with your department, period, yours. Ben Hitchcock Ross. Ben Hitchcock Ross. Yeah. All right. So let's get back to what they have to respond. Let's see what they can say to that. You never know. Maybe they've got a fantastic response that puts an end to the whole thing, and I'm a big baby. Very possibly. We'll find out. All right. This letter is in response. Let's see if I can move that. Bam. It's like magic. To the accusations contained in Attorney Hitchcock Cross's, yours truly, February 14th, 2024 email. In that email, Hitchcock Cross, ooh, I like that one. Attorney Hitchcock. I will admit that Hitchcock Cross is an assault on the maxillary bone. I absolutely admit that, and it's how the cookie crumbles. If I was like Lord, Saltley and North or something, North and Westbridge or whatever, there's a lot longer names than that, but still, pretty amusing. All right. So, but now, I mean, point is that I would have also accepted BHC. Wrote that his client, Teresa Folleron, received a threatening telephone call with what he believed to be the sound of left on Miss Folleron's voicemail. Well, I'm going to rewrite that sentence real quick for old, and I'm pretty sure this is Ryan who's writing this. Sorry. Yep. J. Ryan. All right. Oh, I wonder what the J is. J-A-Y are the letters of his name. Jeez. One's tempted to think of something other than cutting and scratching, but we'll leave that aside for the time being. I wonder what the aspects of Ryan's game is. Comments? Yeah, I feel like I'm going to leave that aside. It wouldn't be in the best traditions of the guild were I to fill in those blanks myself. Okay. But I do like this. Moving on to Hitchcock Cross. That's not bad. All right. But I will say, in that email, Teresa Folleron received a threatening client. So again, I'm going to put that in the active voice. We can give him a, pretty sure we can. Dang it. It's going to be one of these. It's going to be one of these. Oh, well. Ryan, you got them all. So here's the passive voice alert. Let's say that MPS threatened Teresa Folleron in a telephone call with the sounds of 4 left on Folleron's voicemail. Does that sound better? Because nobody left that. Well, that's not the case. Somebody did it. And although we don't know who that somebody specifically is, we know who does. because they have the phone logs, they have the video. There's no question that MPS could find out exactly who was in that office at that time and should have already done that. And the police should already be doing that. If they are or not is a different story. But to say that what I believe, I don't even know. Do I say what I believe? I mean, yeah, no, I don't quit. I don't say what I believe it is. I say that that's what it is. So, but just in case you don't believe me, MPS has thoughtfully included the recording of the voicemail that we've played now. So you can make your own determination as to what you believe. Cool. All right. Hitchcock Cross claims MPS is blatantly attacking the authority of this tribunal and the DWD by threatening complainants, including Ms. Folleron, who come before the tribunal with equal rights complaints. Ooh, that's a quote, and I did say that. Hitchcock Cross bases this accusation on the fact that the call occurred during a scheduled deposition. Okay, I'm sorry, just unpacking that sentence. The fact that the call, okay, so they agree the fact the call occurred during the scheduled deposition, okay, and the fact that the alleged location of the caller was a secure MPS building. That's a strange use of that. The fact that the alleged location of the call. I didn't make that allegations, by the way. I understand that from MPS people, and we've played the number there. That is a phone, and so they can verify that or not. I just don't even know what they're saying. The fact that the alleged location was a secure MPS building. Okay. These two facts fall far short of proving Hitchcock Cross's very serious allegation. Let's go back. That this is undermining the authority by threatening complainants. Oh, there is no evidence to support Hitchcock Cross's allegation that the MPS threatened a complainant or any other complainants for bringing an equal rights complaint. I'm sorry, this tortured look on your face is that this sentence seems to be completely in contradiction to the previous sentence, possibly two. Hitchcock Cross, the fact that the call occurred during the scheduled deposition in the ERD matter. Okay, that's two. And the fact that the alleged location of the caller was a secure MPS building. So that's three facts. So, I mean, that's three pieces of evidence that support Hitchcock Cross's accusation that MPS. Do you see what I'm saying? That last sentence there seems to be completely contradicted to. I mean, okay, again, even the sentence before that, the two facts fall short, far short of proving very serious allegation. Now that somewhat makes sense with the first thing. I disagree with it, but at least that he could have let it like that. But to say that they fall far short is completely contradictory to the next sentence, which says there's no evidence. You see what I'm saying? And when you make statements like no evidence or everybody or all, you're oftentimes setting yourself up for failure because all somebody has to do is to produce one example. And here it seems like they've produced three examples. So that's somewhat, I guess we could do like the three. That's tricky to me. All right. This appears to be just another attempt by Hitchcock Cross to damage the reputation of the respondent in the eyes of the tribunal and to improperly influence future rulings by the tribunal. First of all, you gotta if you say it's just another attempt, I mean, my guess to unpack that is that they feel like the motions for sanctions and to compel are attempt to damage the reputation of the respondent. But I don't know. I mean, it's, um, I don't get that. I just don't. Again, I would need more. If there was some examples, I think I could respond to that, but that's just too vague. The improperly influence future rulings by the tribunal. I mean, are they saying they didn't do it? All right, well, let's find. Maybe they give us some more detail. I'm just trying to figure out the logic of that last sentence there with regards to the previous stuff that they themselves wrote. So, all right. From a recording, Miss Folleron forward to MPS via email. Okay, and this is the one that they've attached. The call appears to be made on January 8th of 2024 at 9:09 a.m. Okay, so they agree with that. Oh, they even put a little footnote on the recording she attached is being submitted to the tribunal. Good, so we're 100% clear that that's in the public record by their own efforts. Thank you for that. According to Ms. Folleron's email to MPS, she was not aware of the voicemail message until the afternoon of February 12, 2024. Okay. She also notes in that same email she has already encountered someone outside of the school with a gun and a stranger coming into the building to threaten her on the second floor. Okay. I'm going to read this sentence straight out and then we'll see how I think I can bring it together. Hitchcock Cross did not claim that MPS was blatantly attacking the authority of the tribunal and the DWG as a result of those two other events. I don't know what's doing that, but it's really annoying. But I think we can do this. We good? All right. It's always something. Hey, so, but it was really appropriate. If there's a ghost, let's assume there's, just for the sake of argument, that there is a ghost in that, the Rodecaster Pro 2. It's got really good taste. So good for you, Ghost. All right. But there's appropriate time and an inappropriate time for such things, Mr. Ghost. All right. Or Madam Ghost or Ghost. As it will. What's really bothering me here is the use of just Hitchcock Cross. And it's sort of like Von Briesen. It makes me feel like I'm putting on airs to just say Hitchcock Cross. So, like I'm the Lord or something. I guess there's reason I can get into my little barren story of St. Cloud at some other time. Here, but that's why I'm feeling sensitive about that there. But I'll take Hitchcock Cross. Okay. Now, I think it's fair to say that it's true that Hitchcock Cross, and it's really strange to just be distinguishing between the identity of the attorney and the identity of the complainant. Because as I've often expressed here, I am just the complainant. I'm nothing more than that. I'm not Attorney Ben. If I'm representing you, I'm you. And so if I say yes, you've said yes. If I say no, you've said no. And everything in between, I'm your agent. So in this relationship, I happen to know a lot more about the law. This hypothetical relationship, I happen to know a lot more about the law in my business of how to, advocate on your behalf than you do probably. So it's more incumbent on me to, get that out there. But I just want you to be clear. If I say yes, no, or something else, it's binding on you. So again, it's just a strange wording, and it's not the usual practice here, but it happens to me frequently, I think, because I kind of get in people's bonnets from time to time, that they're personifying me as opposed as distinct entity from the client. It's also sort of a way to put a wedge in between the two of us, as if there's a space of no distance between me and my client. Come on. All right. So again, we're just criticizing this last sentence here. And again, criticism, by the way, can be perfectly fairly met. It can be well meant. It can be negative. All of those things. Hitchcock Cross, I'm going to rephrase that. The complainant did not claim that MPS was blatantly attacking the authority of the tribunal as a result of those two other cases. Absolutely true. Don't deny it. Don't deny it. Couldn't deny it. Okay? We mentioned them as things that happened to her as a result of her filing whistleblower complaints. And the issue with that wasn't that she encountered somebody with a gun outside of the school, because I think that happens to teachers on a daily basis at MPS. I don't think that's like shocking. It's just that when she asked them to do something about it as a central services person, they did nothing, that's part of out of the ordinary. And also a stranger coming into the central office to threaten her on the second floor of the central office, that's noteworthy, because you try coming into Posley's office and see what unannounced and see what happens on the second floor. There's some unpacking that we had to do there, but I think we got through that one. God, by the way, I'm going to say this out loud. Don't email, contact, otherwise make any negative comments to anybody in this that's involved with this letter, any other things that we do here. These are public records. You're absolutely available. These are public people, but we don't want to go and just because we don't. All right. Unfortunately, I mean, all right, man, I'll give him this whole benefit of this whole paragraph. Respondent is once again compelled to respond to Hitchcock Cross's false and frivolous allegations relating to the deposition of Dr. Jacqueline Mann. Apparently, we need to have a sound effect for personification of the attorney. But again, I will say that part of my job is to have the focus of the respondent on me and not the complainant, sometimes for good or bad. But that's why I handle these kind of cases. All right. False and frivolous allegations related to the deposition of Dr. Jacqueline Mann. First, as previously explained, Hitchcock Cross failed to offer any evidence that the voicemail message is related in any way to the deposition of Dr. Mann. As such, there is no reason for him to mention that deposition in his email. Okay. Let's go over the timeline here. Deposition, 9:09, 9 o'clock. Voicemail sent to complainant, 9:09. While complainant is attending the deposition of Jackie Mann. These are, according to the facts that he says, the call occurred during the scheduled I just, again, as previously explained, Hitchcock, but they didn't again, the previously explained part, it's a rhetorical device. It's not, and again, as previously explained, we went through that trick, how it went there was very little and then now none, falls far short, and then went to none. Mention that deposition in his email. So, and I just want to point out, to explain to everybody that we've already filed an equal rights division complaint against Milwaukee Public Schools for what happened as violating the complainant's rights to file a complaint without retaliation. So we will get to the bottom of all that. They've got to hold on to all of the relevant materials. I better call them and remind them of that. All right. Secondly, Hitchcock Cross falsely claims that the respondent and its attorneys knew that Jackie Mann would not show. It is unfortunate that Hitchcock Cross must continue to conflate the truth with his unsupported conjecture, insinuations, assumptions, and unfounded beliefs. Ooh. Insinuations, assumptions, I think much of that is redundant. I think unsupported conjecture and unfounded beliefs are synonymous. Insinuation, I think that's slightly different. And assumption is also synonymous with unsupported conjecture, in my understanding. But hey, which kind of indicates to me that somebody's kind of angry. As respondent explained to this tribunal and to Hitchcock Cross by email dated January 9th, respondent did not know if Jackie Mann would appear at her deposition. She might have appeared, she might not have. We don't know. Okay. So again, I don't believe that. Let's just go straight to that point. Respondent also reminded Hitchcock Cross, as well as this tribunal, at a prior conference that the respondent had been unable to contact Dr. Mann. Okay, that was prior to the notices and prior to everything else, and they still had conversations. But that's just, I mean, besides, we've already talked about why that's all bad faith there. But I just don't believe them, is what I'm trying to say. And the fact that they don't know where their board officer is again unbelievable and immaterial, because it doesn't matter. The fact that she hasn't produced means that they lose the whole case. So we're going to get to that later, but we'll get to that later. This tribunal unable to contact Dr. Mann, again, totally unbelievable. You know where the checks are coming from. And the tribunal that, given her position, respondent was not responsible for securing Dr. Mann for her deposition. False. Despite that fact, sent a notice of deposition for Dr. Mann to the counsel the next day. Respondent attempted to con Dr. Mann again after receiving the notice. Let's get that in sworn to there, guy. Again, after receiving the notice, in fact, emailed a copy of the notice of the deposition to Dr. Mann, and Dr. Mann didn't respond. Well, I think we're going to get that now. I think that's going to be a pretty big factoid to deal with. Did not know whether Dr. Mann would appear for her deposition or not. Well, dude, it just said a paragraph before, it said that you did not know if Dr. Mann would appear. And now you're saying they didn't know whether she would appear or not. I mean, it's like seriously the topic sentence of the next paragraph. That to say that somebody, I don't know if you would appear, is different than saying, I don't know if you would appear or not. Okay, why is it different? Obviously, somebody could appear or not appear. Those are obvious. If it's possible that somebody would appear, it's also possible that they would not appear. Okay? But the question is what did you know? So if you had some knowledge that you didn't know if she would appear. Okay, that's fine. And it is absolutely different. That's possibly what they said. I think we have that video, so we can go look at it. But they didn't say it was possible that she would. At no time did they ever say, including when we talked to them days before that deposition or the day before the deposition, did they ever say it was possible that she would not appear? That's the distinction there. It is a distinction. And it's just really weird that he would add this, go from he didn't know if they would to would or not. Had Dr. Mann shown up at the deposition without counsel for respondent present, Hitchcock Cross would most likely have proceeded to with the deposition without counsel. So that's the old Ben is a jerk, so therefore we can break the rules. In short, to state that counsel for respondent knew that Dr. Mann would not show up. Well, you just said you didn't know if she would, that she would show up. Oh my God. Okay, I want to go over this again. They know that they were noticed. So when you notice somebody, you don't also subpoena them in terms of you give a notice to the other person and then you give them the subpoena. But if you're doing a party by notice, this means you don't go around and subpoenaing the plaintiff or defendant in a case, no, in Wisconsin anyway. The parties just simply say, I'm giving you a notice of a deposition on this date. Is that going to work out? Okay. In this kind of case, because there's a board of school directors, all of the board directors are parties, and also officers of the board are also considered parties here. So they keep misunderstanding that because Jackie Mann is an officer of the board, that we don't need to subpoena her. She just has to show up by notice. Okay, so they know, by the way, because of the notice that we gave them didn't have a subpoena on it, that they're the only ones with the notice. Okay, they put that right in the letter. They say that they emailed her and they know she didn't respond. They just, see, that's disingenuous too. Because even I know that Jackie Mann's emails are cut off and have been cut off since they put her on leave. Got him. We need a button for that too. All right. Next day. Respondent attempted to, after receiving the notice, in fact, emailed a copy of the notice and she didn't respond. Got it. All right. By the way, there's no mention in this sentence, in this paragraph here, of the fact that Ryan, as you see in the video, sat there for half an hour and more and said nothing about this fact. This what he's saying here. This is not a fact. It's his cover, I would say. In conclusion, Ms. Fotleron's problems, although concerning, are not problems caused by the respondent and should have no effect on the pending matter. This matter should proceed without further interruption or delay. Okay, I guess that's it. So you just have to say that evidence isn't good enough, so therefore it doesn't exist. And so therefore there's no, even though these things happened at this, then you can ignore the time connection among everything else, or the fact that it came from an MPS location. You can ignore those things and therefore they don't exist. So therefore there's nothing. I think I'm getting the logic here. And again, the attorneys contemplated that it was possible that Jackie Mann could have learned of the deposition somehow other than from them and not responded to them about it and shown up for it. Okay. All right. There we go. I think that's about as disingenuous as it can be. I think that they are feeling the criticism, and I think that we will get the chance to depose a lot of people here and get to the bottom of this. So I think it will be known exactly who sent that, who made that call to my client, and I think it's just a matter of time. So stick with us, and we'll be happy to keep you informed, assuming I didn't completely turn off all of the whatevers. I'm sure I did. Hey, there's theme music on right now, and you're rocking and rolling to it. Take care.